Hawaii's Attorney General's office got the call on a Thursday morning, and within an hour, lawyers in five other states were on the same group thread. Not because they lost a case, because of how they lost it and what losing it means for every state still trying to write the rules on where you can legally carry a gun. This week, the Supreme Court of the United States ruled 6-3 in Wolford versus Lopez, striking down Hawaii's so-called vampire rule, the law that required a concealed carry permit holder to get explicit, affirmative permission from a private business owner before bringing a firearm onto that property. No sign welcoming guns, no verbal yes from the owner meant no gun, even if you had a valid state issued permit in your pocket. Justice Samuel Alito wrote the majority opinion. Chief Justice Roberts, along with Thomas, Gorsuch, Kavanaugh, and Barrett, joined him. Justice Kagan and Justice Jackson dissented, with Sotomayor joining Jackson's dissent. And just 1 week before that, on June 18th, the same court handed down a separate unanimous 9-0 ruling in United States versus Himani, a case that didn't get nearly the headlines it deserved, but which legal analysts are now saying set the stage for everything that followed. I want to walk you through both of these rulings today, what they actually say, what they don't say, who they affect, and why attorneys general in California, New York, New Jersey, and Maryland are treating this as the opening of a much bigger fight. Stick with me through this because by the end, I want to ask you something, and I want your honest answer in the comments. Let's start with the case that's making the biggest waves, Wolford versus Lopez. To understand why this ruling matters, you have to understand what Hawaii actually built after the Supreme Court's 2022 ruling in New York State Rifle and Pistol Association versus Bruin. That earlier decision said the Second Amendment is a real individually held right that extends beyond your own home, and that any law restricting it has to be justified by reference to America's historical tradition of firearm regulation, not just by modern policy goals. States that wanted to keep tight restrictions on carrying went looking for ways to work within that new framework rather than fight it head on. Hawaii's approach was clever on paper. Instead of banning carry on private property outright, which would have been a direct conflict with the post-Bruin landscape, the state flipped the default. Under the old rule, if you owned a Hawaii concealed carry permit, you could walk into a grocery store, a gas station, a restaurant, basically any private business open to the public, and carry your firearm unless that business specifically posted a sign saying guns were not allowed. Hawaii's new law reversed that completely. The default became no. You were presumed not allowed to carry on private property open to the public unless the business owner affirmatively said yes, usually through a posted sign or a written statement. Hawaii's legal team argued this wasn't really a Second Amendment case at all. They said it was simply a property law question, a default rule about consent, similar to how a homeowner controls who can enter their living room. The Ninth Circuit Court of Appeals agreed with that framing and upheld the law in September of last year. The Supreme Court did not. Justice Alito's majority opinion rejected Hawaii's property law framing outright, ruling that flipping the default for nearly every public-facing business in the state functions as a direct burden on the right to carry, not a neutral consent rule. The court then turned to the history Hawaii had leaned on to justify the law, and this is the part worth sitting with for a moment. Hawaii had pointed to old laws from the 1800s as historical precedent for restricting carry on private land. The court found that the strongest of those examples, an 1865 Louisiana statute, was rooted in the post-Civil War Black Codes, laws specifically designed to restrict the rights of newly freed Black Americans. The majority called that history both too tainted and too rare to serve as a legitimate foundation for a modern, statewide rule applying to nearly every business in Hawaii. So what actually changes? The default flips back. If you are a licensed concealed carrier in Hawaii, you can now bring your firearm into stores, restaurants, and gas stations unless the owner specifically posts a sign or otherwise tells you no. That is already how it works in 45 other states. So in a sense, Hawaii just got pulled back in line with the rest of the country rather than being pushed into uncharted territory. But here's what the ruling does not do, and I think this is the most important nuance in the entire case. This decision is narrow. It applies specifically to the private property consent rule. It does not touch Hawaii's broader list of so-called sensitive places, locations like courthouses, polling places, schools, and government buildings where carry restrictions remain fully intact. The court was not asked to rule and did not rule on whether states can designate other categories of sensitive places. That question is still very much alive and working its way through the lower courts in other cases. What this ruling does do is put a target on the back of similar laws in other states. California, New York, New Jersey, and Maryland all have versions of an affirmative consent requirement for carrying on private property. Some of them passed in direct response to Bruen as part of broader public carry frameworks. Legal challenges to those laws are already in motion, and Wolford versus Lopez just handed the plaintiffs in those cases a very specific, very recent precedent to build their arguments around. Watch for emergency motions and new lawsuits in those 4 states within the next several weeks. Now let's go back 1 week to United States versus Hemani, because I think most coverage buried the lead on this one, and it actually tells you something important about where this court's thinking is heading. Hemani is not a permit case. It's about a federal law, specifically 18 U.S.C. Section 922 G3, which makes it a felony for an unlawful user of a controlled substance to possess a firearm. Ali Hemani, an American-Pakistani dual citizen living in Texas, told authorities he used marijuana regularly. Under the government's reading of the statute, that admission alone was enough to permanently bar him from owning a gun, regardless of whether he had ever shown any sign of being dangerous, regardless of state law in Texas around marijuana, regardless of context. The government did not argue that Hemani was a threat to anyone. It argued that the category itself, regular drug user, was sufficient grounds for an automatic status-based firearm ban. Justice Neil Gorsuch wrote the unanimous opinion rejecting that argument. The court held that the government had not carried its burden of showing the prosecution was consistent with the nation's historical tradition of firearm regulation, the same Bruen standard at the heart of nearly every major Second Amendment case since 2022. Justices Thomas, Jackson, and Alito each wrote separately, signaling that while all 9 agreed on the outcome, they don't fully agree on how broadly the reasoning should extend going forward. I want to be precise here because a lot of the early online commentary overstated this ruling. This is not blanket legalization of gun ownership for drug users. The court did not strike down the underlying law. It explicitly left open whether the government can still disarm someone it can actually prove, with real evidence, is dangerous because of their drug use. What's now off the table is automatic status-based prosecution, charging someone simply because they fit a category with no individualized showing of risk. Case-by-case prosecutions backed by genuine evidence remain possible. The narrow version of this ruling is the accurate one, and it's also the more interesting one because it tells you the court's appetite right now is for individualized, evidence-based restrictions rather than sweeping categorical bans, whether those bans come from a federal drug statute or a state permitting scheme. Put those 2 rulings together and a pattern starts to come into focus. In both cases, the government tried to use a broad categorical rule: no carry unless explicitly invited, no gun if you fit a status category, instead of an individualized showing of danger or a narrow historical analog. In both cases, the court said the categorical approach goes too far. That's not a coincidence. And it's exactly why legal trackers following the Second Amendment docket describe these 2 decisions as bookends to the same term, even though they involve completely different fact patterns. So what happens next? A few things are already in motion, and a few more are worth watching closely. First, the lower courts. With both of this term's major Second Amendment cases now decided, the Supreme Court had been holding several other pending gun cases, ones dealing with magazine capacity limits in California and Washington, semi-automatic rifle bans in Illinois and Connecticut, and age restrictions on handgun purchases for 18 to 20-year-olds. Those cases had been sitting through repeated relists, some of them distributed for conference nearly 20 times without action, almost certainly because the court wanted Wolford and Hemani settled first. With the argued docket now cleared, expect movement on at least some of those petitions. A cert grant, a denial with a written dissent, or a grant vacate remand sending a case back down for reconsideration in light of these new rulings, any of those outcomes could come soon. Second, watch the states directly affected by Wolford. California, New York, New Jersey, and Maryland all maintain some version of the affirmative consent rule the court just struck down in Hawaii. Their attorneys general aren't going to simply repeal those laws voluntarily. Expect them to argue that their specific statutory language differs enough from Hawaii's to survive, while gun rights organizations file new challenges arguing the opposite. This is going to play out state by state, courtroom by courtroom over the coming months, not all at once. Third, the broader sensitive places question remains genuinely unresolved. Earlier this year, the court declined to hear a challenge to Illinois' ban on carrying firearms on public transit, letting the Seventh Circuit's ruling stand without comment from any justice. That means there is still no Supreme Court guidance on what exactly qualifies as a sensitive place where carry restrictions are constitutionally permitted. Woolford did not touch that question. It's a live, unresolved fault line, and it's probably the next major fight. Now, I want to be honest with you about what is fact and what is still uncertain, because that distinction matters enormously here, and a lot of online commentary blurs it. What is fact? Hawaii's affirmative consent rule for private property is struck down, and the default has flipped back to allowing carry unless an owner says no. What is fact? Automatic status-based firearm prosecution of drug users without any individualized evidence of dangerousness is no longer permissible under federal law. What is still uncertain, whether California, New York, New Jersey, and Maryland's similar laws will fall the same way, since their specific statutory language hasn't been tested yet. What is still uncertain, how the court will eventually define sensitive places, a question that remains completely open. And what is genuinely unknowable right now is what effect any of this has on public safety. The criminology research on right to carry expansion is mixed, with some studies showing reductions in certain violent crime categories and others showing increases in specific contexts. Anyone telling you with total confidence that this makes anyone safer or less safe is going further than the evidence currently supports. Here's what I think is genuinely significant about both of these rulings beyond the specific facts of Hawaii or Texas. For the past several years, since Bruen came down in 2022, lower courts have been struggling, sometimes openly, with how to apply the history and tradition test the Supreme Court established. Some judges have called it unworkable in practice. Litigation under the Second Amendment has surged since that decision, and judges have reached wildly different conclusions from similar historical evidence depending on the circuit. What Woolford and Hamani both signal, even though they're separate cases on separate facts, is a court that keeps coming back to the same basic instinct: categorical, status-based, default no restrictions don't survive close historical scrutiny, while narrower, evidence-based, individualized restrictions might. That's a meaningful signal for every state legislature currently drafting gun policy in the post-Bruen landscape. Broad brushes are vulnerable. Specific, narrowly tailored, historically grounded rules have a better chance of holding up. Expect state lawmakers and attorneys general on both sides of this debate to read these opinions extremely closely in the coming months, because the next round of legislation and the next round of litigation is going to be built directly on top of the language in these two rulings. I also want to flag something for the people who carry guns for a living or who interact with people who do, because the human stakes here aren't abstract. A small business owner in California who has quietly posted a no-gun sign for years now has a Hawaii precedent sitting on the shelf if their state's broader consent law gets challenged in court, and they may need to think about whether their existing signage actually satisfies whatever standard eventually emerges. A permit holder who has been turned away from stores under an affirmative consent law may now have a much stronger legal argument if a similar law in their own state gets struck down following Woolford. None of this resolves instantly. These changes move through courts, not overnight news cycles, and that gap between a ruling and its real-world effect is exactly where a lot of confusion and misinformation tends to spread online. So here's what I want to leave you with. This is not the end of the post-Bruen legal fight over guns in America. If anything, with both of this term's major cases now decided and a backlog of magazine ban, rifle ban, and age restriction cases waiting behind them, this is the moment where the next wave begins. The court has now given lower courts and state legislatures 2 more data points on where the line sits between a permissible historical regulation and an impermissible categorical burden. How those data points get applied to magazine limits, to assault weapon bans, to age restrictions, that's the fight coming this fall and into next year. I'll be tracking each of those cases as they move because the docket right now is genuinely active in a way it hasn't been in years. If you want the accurate version of what's happening, not the panicked version and not the dismissive one, that's what I'm here for. So tell me honestly in the comments, knowing that the default on private property just flipped back toward allowing carry unless a business says no, does that change how you think about walking into your local store? And separately, do you think the court's instinct here, narrow and evidence based over broad and categorical, is the right read of the Constitution? Or do you think it's going to make it harder for states to write workable gun laws at all? I read every comment, and this is a conversation worth having carefully, not loudly.